Sorry. Aloha, everybody. Thank you for joining us. I'll call the meeting to order. First up, we have a roll call. Dylan, please.
Yep. Bernal,
Here.
Pahinui, Melendrez, here. Oshiro, here. Smith,
Here.
Beret,
Here.
Yoninaka. Here. All right, we got 5 members present.
Thank you. Just so you know, Kathleen is not feeling well, so that's why she's not here. So first up on our agenda, after that, are public concerns. Do we have anybody who wishes to discuss a public concern that is not otherwise on our agenda?
Claire Santos.
Claire, please go ahead.
Aloha and thank you, Commission. I'm Claire Santos, a member of Neighborhood Board number 10. I've been on that board for about 1 year. I have actually 3 quick items to ask you to consider that are of public concern because they concern our board. Please consider removing Punchbowl from the Makiki Neighborhood Board. That board is way too large. It's not manageable. We can't achieve quorum. And Punchbowl and Makiki don't match together. Neighborhoods should match together if they're going to be on the board. Second is, when a person is new on a board, they should be trained and educated on their rights and responsibilities, Robert's Rules of Order, the governing documents. None of that happened for me. And I kind of did what everyone else does and go to Mr. Tom Heinrich for guidance and get myself a copy of Robert's Rules of Order. I would also like to see term limits and rotation of officers to prevent cronyism and fiefdoms from developing as we are seeing happening in some boards. And I would like this commission to take a critical eye to Neighborhood Board number 10, perhaps assign an oversight person. I had a long talk with Lloyd Yoninaka today, Secretary Yoninaka, about the goings on, and won't expound upon them here, except to tell you I did withdraw my candidacy for the next round. I brought a lot to the table at the board. I started a lot of initiatives and got community engagement, but it's an uphill battle, and it's not worth the fight if the whole team isn't working together. So those are my concerns, to keep our neighborhood boards viable and have the community participating with trust that we will be there to help them achieve their goals, to reach out to government and entities and agencies to help them with their problems and not be a self-service kind of political board. Thank you for hearing me out. Aloha.
Aloha, thank you. Are there any other public concerns?
Robert Armstrong.
Bob Armstrong, go ahead, please.
Thank you, Chair. It's great that I'm following Claire and her comments, because as a courtesy, I wanted to let the Neighborhood Commission know about our meeting on Saturday. There's been quite a bit in the press about it. Civil Beat had an op-ed of mine yesterday. It's at 10:30 on Saturday at St. Andrew's Cathedral, the Van Holt Room, and it is designed to do the things that the city hasn't done, which is reorganizing and revitalizing and refreshing the neighborhood board system. I'm really sad to hear Claire is withdrawing her candidacy. I hope she changes her mind, because we need people who keep the feet to the fire and who will not be satisfied with the status quo. We need to be more effective, to be more democratic, and to be more engaged in our community. And that's our plan. It's our second meeting, and I hope anyone who's interested in listening, the folks on the commission, will attend. Thank you.
Thank you, Bob. I'll be there. So.
Thank you.
Yes. Thank you. Any other public concerns? Thank you very much for that. Next up on our agenda, we have our approval of minutes. Hopefully our committee members have had an opportunity to peruse the minutes. Are there any amendments to the minutes anybody wishes to offer?
No.
Thank you. Well, I guess we need an official vote, right?
If there's no corrections. Then
Okay, so they will be adopted as distributed. Thank you very much. So we're ready for our new business. We have a review of the complaints provisions. Sorry, review of complaints provisions, kind of overview. And we did talk about that the last 2 meetings. We've been talking about that, and we've sort of just come up with brainstorm. So actually tonight we do have a proposal. That proposal is on our shared drive. I'm sorry, had not been available until this afternoon. It is there, so please take a look at it. We will try to bring it, or we will bring it up probably during the meeting if it suits that particular moment. So with that said, we can actually start looking at it. I will kind of go through it. If anyone has any questions or concerns, please just raise your hand or let me know, and I'll be happy to take any input. But first off, we have just the, sorry, I want to get my other one to make sure any changes. It's basically just the complaints. It's not section 218-101A. I don't think is a big change. It's just who can follow the plan. There's some changes as we go down. So one, you have the executive secretary, the commission, the board, or a member of the board, or a member of the public. That's who can file, and it basically says how you can do it. One of the changes that we made is provided by the commission office, or once you file, the commission office has 10 days. Or I'm sorry, I misstated that. What we changed was, it used to be 45 days after an incident you had to file. We changed, or we're proposing that be changed to 10 days. The reason being is that the commission just, in general, feels that the process is too lengthy, and we wanted to make it more efficient. One of the big complaints that we hear about the complaint process is it takes so long to complete. So we've tried to streamline it. That was one of our efforts to streamline. So moving on to B, so B simply stresses that the complaint process is about the neighborhood plan. It's not about other extraneous complaints that you have, whether someone violated something else, and that includes sunshine law. We cannot make pronouncements on the sunshine law. That has to be Office of Informational Practices. We can only opine and make decisions on the plan itself, and so that just stresses that. So this is where the next really big change comes in from the current status, and that is C. The executive secretary shall review all the complaints coming in, and in consultation with the approval of the commission chair or the chair's designee within 10 business days, shall have a variety of options. And those are 1 through 5, essentially, or really 1 through 4. And that is, the first option is just combining. Sometimes we've had complaints that have been very similar, arise out of the same set of facts, that sort of thing. So the executive secretary, along with the commission chair, can combine all those complaints into one. And that just makes it a more efficient process. 2, the executive secretary, or the 2 of the folks that we discussed, can dismiss the complaint if they determine it is unjustified or intended to harass. The complainant may appeal that dismissal to the commission. Number 3, those 2 can forward it to the commission just for a hearing. Number 4, assign to alternative complaint resolution as defined below, which we'll get to that in just a second. And finally, if the 2 cannot agree on the disposition, it will be forwarded to the commission for a hearing. So that's basically, we're allowing the executive secretary, in consultation with the approval of the commission chair, to make some choices about the actual, about how to dispose of an incoming complaint. So just to notice the respondent, or shall notify the respondent within 10 working days after the filing. The complainant within the 10 days, just to let them know what's going on and how it will be disposed of. And The number 3, the commission will be notified of the actions, and basically that's really important, especially if the 2 individuals dismiss complaints, just so they can give us a report. The alternative dispute resolution, which is defined in section E1, it starts talking about the commission or the executive secretary and the chair can send it to this thing called alternative complaint resolution. And that can be to the board chair, which the chair will conference or essentially meet with the complainant and respondent. If the chair is the subject of the complaint, the vice chair will head that meeting. Another option, and these are options for the executive secretary and the commission chair. A third option is to have a neutral third party that shall essentially be over that meeting or moderate that meeting. And then number 4, this is a sunshine law issue. So it's like if the complaint does go, then there should be a procedure for automatically establishing a resolution committee for that particular board. And then because we have to go, if it's more than 2 members, you have to go through the sunshine law problems. It'd be nice to have just a meeting and everybody hash it out, but due to sunshine law issues, we're required to do this. And that's why the purpose of that is, and it's just basically then they follow 1 through 3, depending on the circumstances. Are there any questions this far? Oh, okay. Kevin Lai, please go ahead.
Chair, thank you, and thanks for sharing the file. I did circulate my notes to the members of the committee and to Dylan, just in case they're of use. But I just want to comment briefly, because I only had a chance to review in depth this document up through subsection C. So I did have some questions about it. First, I want to make sure we all know that the commission is and will remain a board as per definition, so that I hope that's not something that will be excluded or carved out from any potential changes with application of the Sunshine Law, if such is approved or goes through legislation as has been suggested.
Oh, Kevin, can I break in there for a
Please.
minute? I'm not sure I'm following you. What do you mean the commission shall be a board?
Oh, I just want to make
Versus
sure. Right. So within subsection A, complaints, any person, board member, within other portions of the neighborhood plan, and it looks like this is not exactly the renumbered version of the plan that's mentioned in the meeting agenda. So I assume that the remainder of the neighborhood plan is still in play in some fashion. So the commission itself is defined as a board. So I just want readers of this document down the road to know that, yes, commission members are also subject to this process. Is that indeed the case?
I don't think so, because I think we're the commission members, because in the rules it's commissions and board. Well, anyway, I'll let Lloyd.
Well, I was just going to, Kevin, it's Lloyd. According to the plan as it is now, you can file a complaint against a board member or a board, but the plan does not include the commission as a group that you could file a complaint against, as you well know. So I don't know if that addresses what you're concerned about. Are you looking at the commission under this? Yeah.
Yeah, I just want to make sure that we're consistent throughout with all definitions. So if we are using the word board here and other parts of the document say that the commission is a board, then we need to make sure that there's a carve out if necessary, or there's another means by which the concerns could be addressed. That was just the first thing.
I think under state law, there are commissions and boards. And yeah, a lot of the same things apply, but they are separate. So I'm not sure that we need to say the commission is not considered a board for these purposes. I mean, that would be my conclusion. If it's a problem, we're going to get this reviewed by corporate counsel at the end of the day. So if that's a problem, he or she will let us know.
Okay.
Right.
Yes.
So if you look
I'm
at
sorry.
211-102, it maybe it's not an issue. I just want to make sure it's there. So thank you for addressing.
Okay.
that.
If you would actually email me a little bit more to make sure I clarified or I'm clear on the issue, then I can follow up more.
Okay,
Okay.
thank you. Thank you.
Okay.
Regarding,
Just 1 second. Let me let one of our committee members chime in. Stephen.
Question was, what does the charter say?
I think what good question, but I think that what the charter says is that there shall be a commission, and the commission shall develop a neighborhood plan for the neighborhood boards. So it's the commission's job to develop this plan. That is their purpose. At least initially, that was the way it was created. As far as the charter is concerned, it does separate boards and commissions, like you said. So none of this stuff in the plan is pertaining to the commission. It is pertaining to the neighborhood boards.
I was following the train of thought because Kevin was talking about a complaint process. We talked about that. Then we were talking about boards and talking about commission. And I don't mean just this commission. I mean the charter for the county, which covers all commissions. Is that an area where a commission is commissioned by definition in the city county? So in the city charter, do we know if they allow that process, which is on the boards, to be extended out to the commission as a complaint process?
No, because the complaint process only exists in our neighborhood plan. The complaint process outside of that for a commission is basically the legal system.
I think, you have to go to.
Or OIP or something.
Well, because we can't adjudicate complaints against ourselves.
Right.
Yeah, so I don't think that we're subject to the plan, to tell you the truth. I think that's subject as far as a commission itself. I think that there are other avenues you have to pursue, and I'm not sure exactly what they are. I assume is probably you have to go to circuit court, but I'm not sure. If that's ever an issue, then we can find out, but I don't know.
Or council lists.
Yeah, this discussion, I agree.
Okay. Are we ready? All right, Kevin, please go ahead with your other questions.
thank you. And again, just to clarify, yes, I know that our current neighborhood plan defines board as particularly to neighborhood boards defined by the plan. But again, when you step outside of that to sunshine law, there's specific mention of boards, which applies to a much broader span. And so unless it's eminently clear in our neighborhood plan that it doesn't matter, just want to make sure that if there need to be a clarification, that would. I think we all got that. Thank you so much.
Thank you.
I'm looking at subsection B now of revision 218-101. It looks like there may be a missing word in the second sentence. If it should read, any other complaint or portion thereof shall be ineligible for review under this chapter. To me, that seems to read better. And I might also go so far as to specify that only violations of the neighborhood plan shall be held as complaints, unless, again, we assume that a naive reader who jumps right to this section of this document knows and understands that it's only and exclusively about the neighborhood plan. It just might be useful for a new reader. But those are my comments on subsection B.
Thank you.
Within subsection C, I think if we look at the options in the super subsections 1 through 5, it'll be important to make this considered change. If we don't look at the executive secretary reviewing all complaints globally, but each complaint submitted, then it's better, more easily applicable to the super subsections 1 through 5. So I recommend something along these lines. The executive secretary shall review each complaint submitted and, comma, in conjunction with an approval of the commission chair or designee thereof, within 10 business days of receipt, because there needs to be some reference point to when that 10-day clock starts, shall, and then we get to the subsections 1 through 5. Of those, my concern is that if number 1 is chosen, that does nothing to make any progress towards either having a complaint or not, or going to remediation or not. So I think that number 1 should be a separate section before the list of options of disposition of any complaints that make it through the initial filter process. So, for example, how would the executive secretary pick option number 1 and option number 3, for example, if each of these is queued by an or clause? That might make it difficult. Regarding subsection number 2, The option here is presented as to dismiss the complaint, subject to appeal by the complainant to the commission, if determined to be unjustified or designed to harass. Well, to harass whom? A respondent or anyone in general? There might need to be a designation there. But more importantly, how and where is this appeal by complainant to the commission defined? It seems that this is not covered already by Neighbor Plan Section 211-104, because this decision is not being made by the commission per se, but by an extra commission employee, namely the executive secretary. So I don't know if it's clear how and where that appeals process will happen, and ensure it happens fairly and equitably in all cases. I think lastly, if we look at subsection 5, if the executive secretary and commission chair or designee disagree on disposal of the complaint amongst the options defined per subsections 2 through 4 above, the complaint shall be forwarded to the commission for a hearing. So is there clarity needed that this would be a hearing to determine the disposition of the complaints, or, as I think you voiced earlier, Chair Smith, if there is incongruity in the two decisions by those two parties, then by default it will go through the hearing process and not to a stage to determine if the complaints will be dismissed or sent to the alternative complaint resolution. I just wanted clarity on that particular question. And again, these are all posted in the file that was sent to the group a few minutes before the start of the meeting. Thank you, Chair.
Thank you. Unfortunately, I didn't have an opportunity to review what you sent, but these are good points. I will tell you that I wrote this morning, so I don't doubt there are this is just a lot of issues. This is just a rough draft, but I appreciate your suggestions. I would say when you talk about, like, in number 2 about may appeal to the commission, that's a really good point. I'm not sure that that's really well defined in here, and that's something that should be included. Thank you. As far as number 5, for a hearing, yeah, we probably should not say for a hearing. There should be a process in the commission. So that's a very good point. Thank you. And it's something I think that we'll consider editing. Okay. With that said, thank you, Kevin. That was very informative. Any other? Any so far? Okay, where were we? I think we were at alternative complaint resolution. This is just what we named the process, and I did think we talked about this. We talked about it can go to the board chair. This is basically to have an opportunity for some complaints which may be better off, that the commission feels may be better off handled at the board level. So we wanted to create at least an opportunity for the executive secretary and, of course, with approval of the chair or the designee, to allow it to go back to the board. And essentially this does. And we say the board chair or the vice chair if the chair is the subject, or a third party, because the secretary will probably have a feel for what's going on. And if it's not feasible, then I'm sure the executive secretary would not choose this option. But this gives flexibility to the chair to assign those types of complaints that might be able to be resolved at that level, to actually go that route. So if after meeting as directed under this section, the complainant may withdraw their complaint if they're satisfied with the resolution, like the meeting, or otherwise, if they're not satisfied, then it will go back to the executive secretary. The executive secretary can then decide how to act on it. I'm sure it will not go back to, obviously, the board, unless maybe they had the board chair moderate, and then they say, well, no, we really need a neutral third party. That would be the only option, the only time it would not. So it just sort of would recycle with the elimination of that option. Okay. No further questions? Yes, I'm sorry. Go ahead.
For the alternative complaint resolution, or what you have, items 1 through 4. So I think this is all at the board. It's outside the commission. Is that right?
Yes. Well, it would come back to the commission. It would allow the complainant, I mean, that's sort of what we discussed. We didn't feel like it would go to the whole board.
Yeah, I think
That
that
was
was
the-
not back to the whole board. However, I think there is, the way I look at it, in terms of resolving it at the board level, the executive secretary or the chair may suggest a member of the commission, be involved.
Because the board resolution committee, I take it that's comprised of neighborhood board.
Well, this is not a committee. The committee
Or it
was,
says
that
to
was,
a neighborhood, to a board complaint resolution committee,
well,
which shall be
May-
automatically established by the board. So I take it that's the neighborhood board.
well, yeah, it's a committee of each board. So, and maybe I didn't articulate that very clearly. What the intent was that they would automatically be created at each board, like let's say neighborhood board 10, which we heard about. If there's a complaint there, you wouldn't have to go through that formal process of creating a committee. It would be automatic. And the reason for that is the sunshine law issue. Because you have to have some vehicle, for the people to meet and discuss this. And so that's what that committee is about. It's not a committee of the commission.
Right.
Oh, okay.
That's what I mean. It's neighborhood board members.
Yes, yeah, I'm sorry.
So how do they designate that? Is it like when you elect officers, you also elect people to serve on this complaint resolution committee? Or is it ad hoc?
Well, yeah, I see it as an ad hoc, and maybe we can put that. So you have either, obviously, the chair or the vice chair. If it's a neutral third party, I mean, my thinking was, if it's neutral, it's outside that board. And then be that a commission member, be it, I mean, that's a generic term, so it could be almost anybody. And that would be the choosing of the executive secretary and with, approval of the commission chair. So that was, I don't know if that needs a little bit more clarification, but that was sort of the thinking of what we talked about. Yeah,
Well,
Steve?
when you title something like this, alternative complaint resolution, I take it, the idea is to, it's like a mediated complaint process, where you follow a model that, mediators follow, I take it. So that's the idea. So, this is not something that you just can dream up. You have to have training in terms of how to resolve complaints or disputes between parties. So this is not an automatic. If you're going to do this, then you have to have training for people that do it, I think. Because you cannot just throw people together and say, go try to solve this.
That's kind of what we discussed.
Especially we got a rookie chair that just came in.
No. Yeah, I remember the discussion, but alternative dispute resolution, to me, infers that it's established.
It's mediation.
Yes, mediation. I mean, you have neutral third party. We just had a presentation from the Mediation Center of the Pacific at our neighborhood board. And one of the things that they were pushing was, landlord tenant kind of eviction mediation, but they do all forms of mediation, such as neighbor complaints. I would imagine they could do this type of mediation as well. So that's what I'm thinking. Is if we were to suggest some kind of alternative dispute resolution, then the people that are doing that should be actually trained in the process of how you handle disputes and complaints, not just throwing people together and say, let's figure this out.
Are you suggesting that we remove this from?
No, I'm not
Okay,
suggesting we remove this. I'm saying that if we're going to put it in, that we have to keep that in mind, that people that may be doing this really need to be trained on how to do it.
Just a question on the mediation center for Pacific. Did they talk about the cost to use it?
No, but I understand that they do have costs and it's voluntary.
Meaning to use it?
Yeah.
Yeah.
I don't
Some
know.
of the mediations are like the courts refer to them, so they pay.
Steven?
2 comments. Right now, committees are optional to the boards. So now you're making it not optional. You're saying there will be complaint resolution committee. That's another big change. I agree with Chair Shaw is that there has to be training. So after this, if you actually create this, you have to come down here, suggest, and actually line item the qualifications of those people that are in the committee and provide training thereof. And also, even if you looked at using the mediation group, I don't know if they'd be qualified to mediate this. They'd have to go through training that we have in order to make that an informed decision. So you're opening up 2 other items, 3 actually.
So my question would be, is this, I mean, I know it's not mediation in the legal sense, but is it not viable? I mean.
No, this is a
not
good
viable?
idea, but I'm just saying, when you do this, it's gonna open up other things that you have to satisfy.
Larry?
I think this is good from a first option standpoint, is design it right, and I think the wording that you have is good. I know if I was doing this and I had an issue, I'd have my vice chair with me, and what I would do is ask for a commissioner or a representative from the NCO to sit in as that third party, and we hash this thing out before you take this complaint to the commission. You take care of it at the lowest level. I like this.
But the other requirements have to be satisfied.
Well,
It is a good idea.
I guess what I would ask is the commission comfortable with leaving this type of thing and, you know, in here and knowing that it would take some legwork, I guess, in the dispute, you know, just in the commission level to make sure it works. But I would remind you, it's an option. So if it's not, if we feel, you know, like if you're chair, if you feel like it's not there yet, then you don't have to slip.
Well, I agree with Richard. I think that when we start a new term, part of the checkoff blocks, we got the new people coming in and everything. I think what it is just a refresher for the chairs to have in meetings. You can have a virtual meeting with all the chairs and vice chairs and say, okay, you need to establish a committee in advance. Okay, who's on that committee? And then when you do have to do in this alternative complaint resolution, you're going to either ask the commission, you can ask the NCO for somebody to sit in because you have some issues you're trying to resolve before it goes outside the board. If you can't, then it's got to go to the
Well,
commission.
I think you have to do it right off the bat because as Patrick said, he views this as ad hoc. So you set it up as needed. I mean, some boards have problems all the time with complaints. So, you know, they likely need to do this.
We have-
Other boards, you don't have any complaints.
I mean, I will say, so if you have member A versus member B, A makes the complaint. So if you set up beforehand and you say, okay, member, you know, C, D, and E are on it, it's not really for them. It's for the complainant and the respondent and be it the chair, third party, or whatever. Not to say if you had a third party, the chair and the vice chair shouldn't be there. But the point is, so it's not like just a set committee and then those folks would show up because then that gets a little off balance, I would think.
But I do think it's healthy because if it is, let's say the complaint is against the chair, okay, from the board member, it's an opportunity for the chair to say, okay, this is why I said this. And you know, and the thing is, if you have to go through this a number of times, then you have a team player issue. There's a chair still running the show, but the chair, and the nice thing is having a third party in there, that's when the third party talks to the chair and says, hey, I would do this a little differently. I think you ought to at least reconsider what the individual is saying.
You know, for example, item 3, for a neutral third party, you know, as part of this process, I would feel comfortable, for example, if we did this, if we had NCO staff, if we had a number of people that were trained to do alternative dispute resolution or complaint resolution or mediation. You know, if they're trained, you know, I could see them doing that. Because right now, if we did this, we don't have anybody that we can point to right off the bat.
Okay, why don't I suggest this is sort of, you know, we're just taking our first look at this. So why don't we think about it? This will be an issue we can kind of circle back to maybe Lloyd, if you want to give some thought as to what we talked about and what you would kind of envision it could look like, you and Dylan, and we can go from there when we discuss it next month.
Lloyd, if it's not NCO staff, if we were to say we can refer them to the mediation center of the Pacific, I mean, that's what they do. I mean, that would satisfy what we have here. You know, I mean, just refer 'em. I don't know if there's a cost, but that may be something we can take a look at. But they do a good job in this area. I mean, that's what they do.
Okay, so
The other comment, if
Yeah,
I
go
may,
ahead.
Patrick, is the word ad hoc, because it doesn't say ad hoc in the narrative. If you use the term ad hoc or paraprofessional, there are groups that do counseling, but they use the term paraprofessional. As a professional counselor, you have to be certified and licensed by the state. Use the word paraprofessional or ad hoc, you're okay. You can do that, but the training is still an issue.
okay. Well, we will look into that and consider it and circle back around to that next month. Yes, please.
Kevin's had his hand raised.
Oh, Kevin, go ahead, please.
Chair, thank you. Just a few questions about this. What I think we're on is 2-18-101 subsection E, sub 1,
Yes.
sub 4. If I look at the very last portion of sub 4, led by an individual as directed by subsections Roman 1 through Roman 3 of this subsection. On the next iteration of this document, can you perhaps clearly define which subsections and super subsections? Because as we're deep into this outline format, it gets difficult to tell which, because I'm not
Yeah,
sure if
that-
this is supposed to be Roman 1 through Roman 3.
It is, and that was my mistake. Sorry about that. Thank you for highlighting.
Just for
that.
clarification. But the broader issue here is this. I mean, I think before this goes into production, there's got to be a significant tabletop exercise where, this process is gamed out. And I've mentioned this in the past. I hope it'll be strongly considered, because you've got to plan for worst case scenarios. Who's on this committee, if a respondent and or a complainant are there. If it is an ad hoc committee, how do you protect against factionism on a board influencing who's chosen on this committee? Can the members of the committee be appealed? The decision of the chair assigning the committee be appealed by someone or some other folks who are either engaged directly or indirectly with the complaint? And I think, again, and I know people who can help do this if you need help gaming it out, but I think it'll be very useful to making sure if this is even going to be a viable option. I'll leave it at that. Thank you.
Thank you. I would say number 2, the ball is in the court, so to speak, of the complainant. If the complainant's unsatisfied, it won't work, or it doesn't. It hasn't been successfully handled. Not that it's a failure of the process; it's just a failure of that particular meeting or mediation, whatever. So, there's not really a need for an appeal. The complainant will just say, no, I'm not satisfied with the result, and it will go back into the process.
Chair, I'm sorry if I may. I was speaking specifically of the definition or assignation of members to the ad hoc complaint resolution committee within a specific board. If there's a way that would be defined as well. Thank you.
Okay, we're looking into that. Thank you. Okay, so we've got a little bit of work to do on that section. I will tell you, Kevin, and for the rest of the folks, this is a rough draft. It's not ready to go out the door. I'll be the first to say that. So just so you know, but any suggestions anyone has, please let me know. So F, you have 4 complaints directed at the board. These are oh, I forgot what the big point of that was. The thrust of F is for notification of the board. There was some discussion about notifying the Board of Complaints. So if member A has complaint against member B, a lot of times in the past, the board itself of Neighborhood Board X, Neighborhood Board X would not really know about it except through the Coconut Wireless kind of way. So a lot of times the desire of the commission, or the committee, was to notify the board, but there might be circumstances that that's not prudent for whatever reason. So this just gives the option to notify for the same two parties. If they are notified of the complaint, then we would expect a notification of the results. And the detail, there again, in all the details, meaning do they name the parties, do they specify exactly what the sanctions are? Those are the types of details that the executive secretary can make some decisions about what extent they want to give. So that's basically the purpose of subsection F. Hopefully it achieves it. Are there any questions? Okay, so
Yes.
Kevin, go ahead, please.
Chair, thank you. Just briefly, but all these actions are still available for public review, right? This is not done under seal or under executive session. I mean, is it the
Yes.
case now that anyone can call executive secretary and say, hey, was there a complaint filed against person X? Is that a legitimate question?
I'll let Lloyd answer that.
You can call and ask me anything. May not
Right,
have
but are
an
you
answer.
obligated to answer?
Yeah, that is a good question. And I have to get back to you on that, sorry.
Thank you.
Okay. Are there any further questions? Okay. So item G. This just sets the day or the timing. And there again, we made it 10 working days that the respondent files the response. And then the executive secretary, as it is now, can extend the deadline if for some good reason in the, opinion of the executive secretary. And then the last part is just if the respondent fails to timely file a response. And again, that comes from the current plan. Okay? So any questions about that? Okay, item H.
So a response can be, as we've seen, can be as simple as I deny all the allegations.
Yes. Yeah, I think so.
Chair.
Yes.
I just noticed on the first page, letter C, that one was the only sentence I saw so far that said referred to as business days. To me, business made more sense than the working day, but I would just advise against the holidays.
There's not a difference between working days and holidays, is there? I mean,
No, just working in business, so you just had two words on there, so whichever one you
so-
like the best.
Which one should we, I mean, I will make it consistent in the next one.
I see his point is well taken, business days.
Okay,
Because
Now more
holidays.
understood by everybody.
okay. I don't know, it's probably
If
just.
it's government, I would suggest working, because so often businesses keep working.
That
government
opens it up for a
stops.
comment, so we say working. We go.
It's the holidays. Are so
Oh, yeah,
different.
they may say that never happens.
Yeah.
Sorry, and I say it with three government workers. Well, so, but I mean,
That's
just
what
say
you get on
business
Sunday.
days, is that okay?
Just keep it
Okay.
consistent.
Well, I will, yeah, and that's an important point, I just messed that up, so if that's it right here. Okay, so, may extend the deadline. I think, okay, so if everybody's okay with that, I'm not sure what the deadline was before about responding, I think they had 45 days, so that is a big change. Kevin, I see your hand, so please go ahead.
Thank you, Chair. Two things. Are we assuming here that otherwise or elsewhere within the revised plan will be the assumption that these are going to be sent by, or notifications will be sent by certified mail? And is that timing?
That's later on in this provision, in this section. We haven't gotten to the notification, the notice part.
Okay. Secondly, I note that there is a significant change in the ultimate sentence of this section G compared to what's in the current neighborhood plan. And it is this, if the respondent fails to timely file a response, any allegation shall be deemed admitted by the respondent. I may be in error here because I think I'm confusing a shall versus a may from the earlier section, but can you explain how and why this word shall will be adopted and put to use? Because in the past, we've seen how this shall has been, lack of a better word, ignored by the commission during a hearing process. So what does this shall mean in this case?
You know, actually, in retrospect, well, in the first place, I think this does come from the plan. Maybe it may be more prudent to make it may, because sometimes there are circumstances which I guess the commission may be aware of, and if we automatically say, we're not going to listen to your allegations, that may tie our hands, and you're right, we shouldn't ignore the plan. So would everybody be amenable to changing that to maybe deemed?
Yes.
Okay.
Chair, sorry, interrupt, Chair.
Yeah, go ahead. Go ahead.
Thank you. That was the exact opposite of what I was trying to apply. It really opens the door for a free-for-all at the discretion of whoever happens to be in the position of power. But this is one chance where a respondent has the opportunity to stand up for him or herself and file a response. If we let that slide, they may not reply either because it's late or they just don't reply and want to tell you their story later on. It really puts the complainant at a disadvantage. I think this is a rule that should be retained, and shall should mean shall. Thank you.
Sorry about that, Kevin. I didn't know that was what you wanted. But I will say, I mean, this is me talking, so I don't want to talk for the committee, much less the commission. But I think the thrust of the process is really trying to get at the truth. And that's why there's no evidentiary type of, well, and it's in the law, but there's no evidentiary limits. There's just, and that's why we don't say, like, if someone turns it in on the 11th day, that they're going to be precluded from putting forth their defense. I appreciate I assume your assertion that there needs to be, there needs to be fixed times and their responsibilities, but that's how I see it. I don't know how the other committee members want to respond.
It's always an interesting question, and I agree with you, Kevin. I understand the need for closure of whatever the issue is, and coming to a final decision. I tend to look at it maybe a little bit different because my perspective is based on, at the end of the day, what's really important is that the issue is resolved for the benefit of the community. And it may not be guilty or not guilty. It may be, the issue is, can we just move on from this issue, agreeing to do a certain thing? I mean, to me, there's a lot of room because it is not a sentence of jail time or a monetary penalty. The bottom line is, at the end of the day, how does it serve the community? And it serves the community better if everybody gets along and we can figure out what's the best thing to do and focus on that. I mean, and that's just my perspective of this.
Anybody else? Is there any desire to change that? Okay.
Kevin?
Well, other than Kevin. Any committee members, I should say. Sorry, Kevin, but I think you're overruled on that. But I understand your perspective, so thank you. I do appreciate your input. Right, is there anybody else? Okay. So moving on, H. Well, that's part of our current plan, and that just, I think that's necessary just for the procedural part. So unless there are any questions, we'll move on to I. And this is the vexatious complaint filer provision that the committee had discussed a a desire to be placed in here. This is based on HRS, not section, so 634J. Anybody can look that up, and I just kind of summarized it. And we'll see what the lawyers have to say about whether it's sufficient. But essentially, if the committee wants to say you're a vexatious filer, they have to pass a resolution. They have to have a hearing to that effect. And once they have a hearing, then the person who's deemed a vexatious filer has to get the leave of the executive secretary to file any future complaints for some reasonable amount of time. We may have to set that. I'm not really sure what reasonable period of time is. I don't know whether it's the term, and I'm unclear. That's why I put that in there as that and did not put a fixed time. So I'm not sure if we can go beyond a term.
What does only upon leave of the secretary?
I'm sorry, what part are you looking at?
The last sentence.
Oh, only upon the leave. Well, that's actually the language in the statute, and it just means you have to get permission. It's a fancy way of saying get permission.
Yeah, if we put
I
it
don't
in,
know
can
why
we
they
put
did
that in instead? Get the permission.
I think that's fine. I mean, that like I said, that's just lawyer language.
That's what
Sorry.
I thought it meant, but I just wanted to make sure.
It's just lawyers love to trip people up, so you gotta pay them to interpret things. But yeah, we can change that. But that's really that's what it says.
That's what I have a question on that.
Yes, sir.
In I, it says the commission may hold an individual, but then the last statement there says upon leave of the executive secretary. Or would that refer back to the subject in the beginning of the sentence, which would be the commission? Should be the commission or the executive secretary?
Well, the commission will hold the person a vexatious filer.
Mhm.
So that's the commission's decision. Once you have that decision, then the executive secretary is kind of charged with reviewing any future filings, and they make the decision. So so it is like it's not. Then if they had to go back to the commission to file in the future, it wouldn't mean as much because then they go back and you'd have to hear the complaint. So
This
that's
is something we have to put in plan. Apply.
Oh yeah. Well, this is plan to go in the plan.
But, I mean, but this is the statute. Which is saying, if we wanted to apply it in the context of complaint process, we have to put it in plan. We
Well,
couldn't just apply the statute.
well, but that's why I summarized it and made it. I think try to apply it. Try to make it applicable to our circumstances.
That's what I mean, but we couldn't apply that without that in the plan.
Yeah, right. I don't. Well, that I'm not sure, and maybe we could.
Because we
I'm not
apply the
positive.
OIP, yeah, to
Well,
a lot of what we do,
Yeah.
as an example.
I don't know. I don't know because I don't know if the commission can go outside the plan, even if it's illegal. If there's like a court could do it. Court can do it, but if it's not in the plan, I'm not sure that the commission could do it if it's not in the plan.
Yeah, I would think you don't have jurisdiction.
Yeah, I would think because we only have jurisdiction over the plan. So we can't just say it's based on law.
But we say often that it's based on the sunshine law. So how does that work?
The parliamentary
What's the
authority,
difference?
Yeah, I
where
think,
it refers to Robert's
What?
rules and.
I can't hear you,
statutes.
sorry.
I think you might be referring to the part of the plan for the boards where it explains the parliamentary authority and how it has the process of when these things are silent, like Hawaii revised statutes, and the neighborhood plan and the revised ordinance of Honolulu, then you would go to Robert's Rules of Order. So you're talking about adding something into there?
No, I'm not saying that. I'm saying that we often cite the sunshine law as to why we do things. So if that's not in the plan, we're already, following, quote, the law, which is sunshine law. But in this case, my question is, can we apply it without having it in the plan? Like we say we follow the sunshine law, can we say we follow this vexatious statute?
I really don't know the answer to that, and that would probably have to be reviewed. I'm not sure, especially if we adopt this plan. I think there's enough kind of leverage that the executive secretary, we have a more streamlined procedure that it's not critical, but I just think it's a good thing to have in here.
Yeah, because now if we see that complaints have no merit, then we just dismiss. You know, that's how we handle that type of complainant. If they file complaints frequently and they are not meritorious, then we just dismiss the complaints.
But there still are, the office, the NCO still has to go through certain amount of work
Yeah,
to handle
yeah,
it. And so that way, if you can even just say in the future,
Right.
you're filing BS complaints, we're not gonna allow you to file. And that's based upon Hawaii law. So it's not like you're taking away any right. And the hearing is the due process part. So they have a hearing about whether they are deemed a vexatious filer. So anyway, okay. Kevin, go ahead, please.
Chair, thank you. I just wanted to ask if it's the intent of the last clause to preclude someone who's been named a vexatious complainer from filing any complaint, even if it's completely unrelated to whatever complaints may have led to the first clause. And secondly, are these terms going to be well defined, or are they accepted definitions within the legal context? Unmeritorious, in bad faith, repeatedly. These are all parameters that looks like they could be subject to interpretation. And it'd be nice if those were defined before the complainant, the denied complainant, needs to go to ask the commission to have a hearing to evaluate the charge of being vexatious.
Okay, so let me take the second part first. Things like bad faith, no, I don't think we're going to define that, simply because that is a very subjective phrase. I would say term, but it acts like a term, but it's a very subjective phrase, and if you define it, you're going to get in trouble. And I don't think the law requires us to define it either. So what was the other part about unreasonable? That again, that's a very reasonable. Sorry, what was the other one? Unmeritorious.
Yeah, same thing.
Yeah, I mean that's the same idea of bad faith. That's just a very subjective and just an opinion of the commission, I guess. So I'm sorry, what was the first question the first part of it?
Thank you, Chair. It was the very ultimate clause. Will a vexatious complainer be limited to complaints about the same topics that were repeatedly unmeritorious and in bad faith, or if there's something new or different, maybe it's more acute, maybe it's totally off, or do they still have to be subject to this appeal? And what timeline will be afforded to this vexatious complainer so that he is able to then file a complaint within the predefined time period? Or will there be a tolling of any timeline while this appeal is underway?
I would say that until they have a hearing and they are labeled a vexatious filer, they are not considered a vexatious filer. So it would not apply. In other words, if I hate to use the word conviction or whatever, but you're innocent until you're actually technically convicted, which obviously those words are extreme in this case, but anyway, so yes, they would not be any until that actual hearing and a decision is made by the commission. There would be no limitation on anyone accused of being a vexatious filer.
Okay, thank you, Chair. But then, in part, yes. So thank you for clarifying that part. But if a complainant is deemed to be vexatious, is that complainant disenfranchised from filing any complaint whatsoever?
Yes, unless the executive secretary allows it. I mean, that's basically how it is.
Thank you.
And you can look up the Hawaii statute, but that's just the way it operates. That's part of being a vexatious, well, usually litigator in this case is how the law is written for. But yes, that's a harsh. I hope that this would not be used very frequently. It probably won't, but at least it's out there as a possibility. Hopefully it'll be used sparingly, if ever. Okay, I think this is Jay. We're talking about our method of notice. So I actually put a little note in here. I don't don't think that we can do this. I think that says we can use first class and email with email preferred. I think under HRS 91-9.5 that we have to use certified. But
But you are correct.
yeah, so when I looked it up, I'm like, so I think from our previous discussions, the feeling of the committee is we'd like to go by the language that is in here, but we don't think that we're entitled to. So that may be a little bit more thought, and if we're not entitled to, then clearly we will keep the registered mail standard.
And this isn't for like really something big for tonight, but this is just from a practical perspective, like on our end, office perspective. I think if the committee could think maybe about some sort of standard in terms of like confirmation of receipt outside of mail, because there are times where we do get the certified mail slip back or something, but there are also times we don't, and we don't always know, like, and we've had other people sign for a certified mail. Maybe it could be a roommate, or it could be someone who, someone else who gets the mail for the person who lives there. And so it's not the actual signature of the person who received it, and so we don't know if they got the mail. It's kind of an issue in terms of like, if you really wanted to confirm that the person who was the intended recipient got that mail. I mean, if we still have to send out certified mail, that's fine, we can do it. But almost in a way of like, at this point, because everyone has email, if there could just be a secondary, like, upon receipt of confirmation of email as well, something like that. Like I said, it's not something that has, just food for thought. As I noted, we do have issues with certified mail, and then
Well, you can have the same kind of issues with email, because nowadays, so many of the email you receive just goes to your junk mail.
yeah, but I mean, I just have
Spam.
nowadays, I mean, yeah, I don't deny that can be a problem, but I just have a significantly harder time saying that the email is as or more problematic than a certified mail going through postal.
Well, let me just say that, so the second sentence is all correspondence sent to the board members' addresses registered with the neighborhood or neighborhood commission shall be deemed to have been properly delivered. I didn't see that falls outside the statute.
I just think there's a lot of times where we just, in practical terms, we just send off certified mail and it's out in the ether. And until we get some kind of receipt back or something, but even then, that receipt could be signed by somebody else. And
But what I'm saying is, I'm not sure that the law requires you. I mean, I know it sounds strange to say you have to send certified, but I don't know that there's a requirement you have to get a receipt.
yeah, it's just
And so,
we
I
just
know that sounds strange, but
we just get worried with then people coming
Because-
back and saying, well, I never got the mail.
Well, I agree with that.
Certified mail, aren't there ways where you can specify that it has to be signed and received by the recipients that's named, rather than just anyone that's
Not
there?
well,
Because, I mean, they can leave a notice to say, pick up your mail at the post
I
office.
think that's just beyond the standard certified mail.
I think so. I don't know
Yeah.
that.
That's
Larry,
part of the options, I think.
Yeah, what I wanted to say is that we need to look at reliability and flexibility. I see definitely problems with the certified mail issue right now, because I got 2 of them the other day. And they're from my board member, for my address. So, but the thing is, though, what if you got somebody that's on a medical situation, went back to the mainland real quick, they need to be notified. Everybody checks their email no matter where they're at. You're gonna have more reliability, and I do believe you need authentication. When you send something back, you wanna know you're relieved, like, okay, that guy knows that we got a hearing coming up. You send him the certified mail, yeah, he's got that mail, but he's got the email that says so. And in there it says, please reply back that you have received this. And when you don't get it back, you gotta keep paying. What do? Pick up the phone. You gotta have telephone in there too.
So for me, it's like I said, if the certified mail must be there, like, okay, we can deal with that. But if maybe there could just be some thought into language that could also put a little bit of weight into, like say email or even phone call correspondence. If it works better to notify someone in another capacity, along with the certified mail, that's still required.
yeah, the problem is, if we put the language in there, then you're gonna be required to do it. I mean, so
It's
that's
much easier-
fine.
It's much easier to send a PDF
Yeah,
email.
that's fine, but I mean, you can already do that. I mean, so it says you have to send the certified. So if you want to send email and stuff like that too, or call, that's best practice.
Well, but we just run into an issue where it's like, yeah, and a lot of times as a best practice, we do send emails along accompanying with things, but that holds no weight on whether or not that's actually considered as the person receiving it.
Well, I think in this case, you have to start, that's why I think, when you say something like it's if you send it to the address registered, it shall be deemed delivered, properly delivered. I mean, what can you do? Basically, to the best of my knowledge, and I might be wrong, there's no requirement you get that receipt back, because, someone could skirt delivery, and I mean, that just happens all the time. So it's not like legal service where we have to hire someone to go out and find that person. It is a slightly lower standard, but if you send a registered mail to the address that the board members are supposed to keep on file and keep current, then it should be deemed delivered. It would be, I mean, we could put additional language, the board should make all reasonable effort via email and phone calls to reach the individual.
Because you send it certified, the receipt is what you get back, right?
Yeah.
Right.
Because you wouldn't send it certified unless you get something back to verify that it was delivered.
But I mean, what else,
I mean, we just got one recently that was signed by somebody else, not to the person that it went to. I mean, to the address, but signed by maybe a roommate or something.
What can you do? I mean, it's we don't have personal service. That's the only other alternative.
But I suggest also though, when you plug in that certified receipt number in the post office, it'll show you the date and the time and whoever, you can see the actual signature or the person that got it. So that's another way to discern before you actually get the receipt back, instead of waiting for it, seeing if it was delivered and who actually got it. Because when you have a PO box, you can you can assign the postmaster to sign for you. But in order to do that, whoever owns a PO box, you have to sign that's legally, you're still responsible for it. But they sign for it, because you get the notice in your mail that it's been signed for, but it's legal that it's
It was delivered.
Yeah,
The
the signer,
signer-
because you're signing for it.
Basically
Yeah,
says
same thing.
that's a lot of work for email in 2025.
Okay, well, why don't
Maybe if there was just some kind of onus on, like, some kind of onus on the person who's being sent the mail, maybe there could be language that way of like,
Well,
to respond to it to something in some capacity.
the response is either they sign or whoever receives it signs. That's the evidence you have. That's as good as you're gonna get from it.
Yeah.
why don't we do this? Why don't you propose some language?
Okay.
And
Yeah, no, I didn't want to spend all night on this. It's
I
just,
know. I'm not sure there's there's probably not a good resolution. I mean,
Yeah, it's
to the problem.
See, I don't care because they do it, not me. But I gotta pay for it. It's $10 a pop.
Yeah.
Well, and it sounds like we're stuck. At least having an alternate, the other ways to deal with it, it will cut some of this out because you can go another avenue maybe.
Yeah.
But okay, well, if you want to, section J, if you want to think of some things, like I said, I think we're stuck with registered certified mail. I'm pretty sure that's where we're going to be stuck.
You're right, I think it is the law.
Okay, so I'd say, yeah, we just go ahead and bite the bullet and say register certified mail. So, okay, going on to K, that is pulled directly from the current board. Oh, I'm sorry, Kevin.
Chair, thank you. In general, does the commission and the neighborhood, or will this process have jurisdiction over committee members who are not board members?
What do you mean? I'm not following jurisdiction.
Well,
Oh,
does the
sorry.
neighborhood, so a committee on a board may be composed of board members and members of the public. So what if that member of the public is subject to a complaint? Are they excluded from this process at the get-go?
They
Because
shouldn't be, but I hadn't really considered that. So that's a good point. That would have to take some consideration.
I think it should be in the process because the board as a whole approved him to be on that committee per the plan.
Yeah, I mean, we should probably have language to clarify and say that they shall be considered well, I don't know, what do you call them, a public committee member or
You
something?
can add that because Kevin's right, the public can be on our committees, but they also report to a board member. So the board member takes responsibility for that committee member. The committee member,
Or committee chair is responsible, not the board member.
Oh.
that's correct.
I don't think it's really possible, like, I mean, like, there's a threshold for things that, like, we require from people being board members, taking oaths of office, handing in certain paperwork, like addresses, phone numbers, emails, you know, like, private information that I don't think you could just, like, demand from a member of the public.
Yeah, actually, after thinking about it for just a moment, I'm not sure we should have jurisdiction over them, but what we should be able to do is if say they do something like breach decorum in a way that we think is egregious, we should be able to tell the board, we can't do anything to this particular person because we can't sanction them. All we can do is say they shall not be considered part of the
Keep them
board
off the
committees. I mean, that's the only sanction we would have in that respect.
But to hold someone responsible, there's a complaint against a committee member that's public, the complaint would go against the committee chair. And they would have to deal with it, their member.
Yeah, I don't know that you want other people responsible for someone else.
That's a premise in law and in subcontract that I write all the time. If someone subcontracts, someone, the prime contractor is responsible for the person's actions.
Well, yeah, but that's like a financial liability. Here, it's a little different. I don't know, what's the feeling of everybody else?
I see it boils down right to the committee chair being responsible for the committee and all actions, the conduct, and to take care of the situation. And of course, if there is a non-team player that's causing, he can't complete the committee meetings because an individual that's not cooperating and listening to the committee chair, then the committee chair should be working with the chair of the board to say, I got an individual, I need to get that person off.
The problem is that, the chair of the board may not be at every committee. So I don't know how you can hold them responsible.
I didn't say committee chair at the meeting. However, you're right though, as ex officio.
No.
Attending those
The
meetings.
neighborhood board chair, I don't see how they can be responsible for a member that's not a member of the board for a committee meeting that they may attend.
No, I think directing the committee chair, working approval to dismiss somebody from the committee.
Well, they can do that, dismiss the person, but insofar as being, when you say responsible, I don't know what that means.
Yeah.
You be the one that, you be the defendant in a complaint?
Well, when I say responsible, I said that is when you're a chair, you have responsibilities.
So, let's, so what I think what I'm hearing and how it would practically function is if there is a situation, a member of the public on a committee does something that's would normally be a violation of the plan if they were a board member. The complaint would go against the committee chair, and basically it would probably be limited. I mean, what else would the board do? They would limit it to this person can't be on a committee, this committee or whatever, a committee
Right.
probably. So I think it probably, we don't need to expand anything in here because the complaint would actually go against the board, the committee chair, which would be a board member.
Right.
Would you agree
Yeah,
with that
because,
analysis?
and the complaint process is pretty clear. It says you can file a complaint against a board member or a board,
Yeah.
and that's it.
Oh.
You can't,
Okay. Go ahead, Kevin.
Chair, I'm sorry. I thought that there was clear language at the top in 218-101. A complaint can be filed against a board, current board member, or a board committee member. So if we need to exclude that particular clause to facilitate the discussion, I'll leave that to be. But Chair, I wanted to say that I think that I may have jumped the line in this question. I thought I saw on the list a hand that had been up for much longer than mine. I just didn't know that list could be surveyed. Thank you.
Well, if it does say a board committee, yeah, you're right, I see that now. That should be changed and removed. Thank you very much for pointing that out. That was a miss. So good call.
Yeah,
So who?
it's in the plan now.
Okay. Oh, it is in the plan?
Yeah, it is.
Okay, so that was lifted from the plan. That was a
Right.
mistake. That's a good call, Kevin. Thank you. Greg Masakian.
Aloha, Chair and members of the committee. I'm sorry, I joined late, and I have been here with my hand up for a little bit. So there was a conversation when I did put my hand up and didn't see it. I just have a quick question and then a comment. You were talking about a vexatious filer, and what I wanted to know is when valid complaints are being dismissed, and there clearly is substantive information in the complaint to show that there's a very reasonable and clear violation of the neighborhood plan or possibly the sunshine law. And we know we have video records, so we're dealing with things that are, at the end of the day, these are factual things that you can go watch, you can listen to. We're not dealing with hearsay most often. You know, these aren't things we should be dealing with in any kind of adjudication. So we're dealing with clear visual recordings, audio recordings. And if these complaints are dismissed and they're valid, and maybe there's bias shown, there should be something in the procedure to address that, because no gatekeeper should have the ability to recommend dismissal for whatever reason unless there's clear validation of what that reason would be. And I would also like to ask what statute you were referring to. You mentioned statutes regarding, I think it was pertaining to vexatious filer. So those are statute pertaining to what you were referring to, because I think everybody has their day in court. And if we did this in the judicial system, I think we'd have a problem. So we shouldn't be taking something in the neighborhood plan that differs from what we do out in our community. And maybe we should see what the legislature does too, but they have some leeway. So those are my comments.
Thank you. So I would comment, this is HRS section 634J, and this is directed at the courts. So it's clearly, it's 634J. It's on the public document that's on our shared drive. As far as the determination of a vexatious filer, it doesn't mean that if someone's filing legitimately disputed, even complaints, or it doesn't mean if they're necessarily dismissed, because sometimes there may be legitimate things, but we just don't feel it rises to a certain level. And I'm speaking for myself in the process, not for the committee or the board, but if we don't feel like it rises to the level of a need to sanction a person, then it could be dismissed. That doesn't mean that it's not, that it's an unmeritorious complaint. So it's a very subjective standard, and that's basically all I can tell you. And,
I think that's
it's
part.
not, well, I would, and one last thing that I would say is, it's not, I don't think, it's certainly not the desire of what I've heard from this commission to cut anybody off. But it is what we believe is necessary in the future to just make sure that we're not getting an avalanche of complaints that are unmeritorious.
Right. If I could add one last comment, I think the reason there may be complaints coming in is because there's a problem. And clearly I know with my board, there's a problem. And those complaints that are coming in are not being addressed. And because they're not being addressed and adjudicated in a proper manner, the problem continues to get worse. And I know Commissioner Smith saw that firsthand at the most recent Waikiki Neighborhood Board meeting. And it's concerning because a member of the public was mistreated, as was I also, because I had the item that I had requested on agenda that wasn't properly on agenda. And
Okay.
simply
Well,
we're just trying to have
we
it.
can't, I know, I was there, I saw it, but this
I know.
is not really the time and place to have that
I know.
particular discussion.
But that's the point I'm making is that there's issues like that that are a concern, and when they're properly addressed timely, then they can be the issues that are underlying that are causing them can be addressed timely. And then you won't have all of these things, and then Executive Secretary Yonanaka won't have to worry about his $10 that he has to spend to send a certified letter. So that's my comment with that. Thank you.
Thank you. I mean, we are trying to
It's not
stream.
my $10.
Yeah, it's not his $10. It's everybody's $10 here. No, we are trying to streamline the process. That's our point. So whether we're succeed will remain to be seen. Okay, so moving on. If we have no further questions or
Well, maybe we can add that in, that the person filing the complaint is. Sorry.
Okay. I hope that was a joke.
That was a joke. That was a joke.
So subsection K is lifted direct from the the current neighborhood plan. So it's no change. So I think we're ready to move on to hearing. If you've noticed from the neighborhood plan as it currently stands, the hearing requirements are slightly different based upon who files the complaint, and that's not done here. It's kind of only one process, and basically it was drawn. This is drawn from the. This is drawn from the language in 103, which is initiated by a board member, or the public, and so that's basically we just took all the language from there. I think I want to say it's pretty verbatim, but there was one specific change. If we just jump down to C, where it's highlighted in our document, and it talks about the list, copies of the list of witnesses, list of exhibits, and evidence shall be exchanged between the complainant and the respondent as soon as reasonably possible. And the reason for that is as there is a recent complaint and there was some question about the 10-day calendar date having the returned requisite documents, and those documents actually being distributed to the parties. There was some question about whether that was, or the 10 days was required in that regard. So after rereading it carefully, I don't think it was, and I think this just sort of clarifies it a little bit. And I think the commission will make it as soon as reasonably possible, hopefully like if it's a 1 or 2 business days, that sort of thing. But unfortunately, like a business day can go over the weekend. So that's why that was put in there. As far as the procedure itself, like I said, it goes on what is already in 103. And if everybody wants to look at it, they can. If they're, I don't know if if everyone wants to take a moment and read through it and see if there are any changes, or we can go through it each part.
Just lifted it.
I just lifted it.
Yeah. Only change to what you highlighted.
Yes.
Yeah.
So, I mean, it's all pretty straightforward. I couldn't see any need to change anything. It's follows HRS Chapter 91, so it's basically a statutory process. So I don't know if anyone wants to make a comment, or if that's something that if you do let me just say, if we will circle back to this next week, we'll make some changes based upon, we'll make changes based upon the conversations here. We'll get some more information. I think there's a provision or two that there was a little questionable. So we will come back to this. So everyone hopefully will get this document, then they can make more comments. So, I'm sorry. Oh, Kevin, go ahead, please.
Chair, thank you. A few comments about this section. And unless and until you've been through the process and have poured over it, you might not realize some of the deficiencies in the language that's been in the document. So a few things. If we can look at 218-102C, not less than 10 calendar days. So I think this language definitely needs to be fine-tuned because the committee rather should consider edge cases. So what if it is one day before an assigned hearing date that the complainant and the respondent shall each file with the commission a list of witnesses? Is that enough time? And does that need to predate or preclude the exchange of information between the two parties? I think introducing language as soon as reasonably possible is still very loose. I think there should be a definite deadline. And the reason for that is this. If we look at the ultimate sentence of Part C, this is the may, shall designation of which I referred to earlier, but this is the one that I have concern about, because failure to abide by the provision of this section may result in exclusion of the witness or evidence or both. Not that it will or shall result. So again, that means that if you don't follow any of these rules, your evidence can be late, it can be not exchanged, but it can still be presented as evidence and considered by the hearings officer, again, to the disadvantage of the other party. So I implore you to please put a mandated time that we can think of now, the committee can think of now as being reasonable, so there is a deadline, and that this deadline must be met. So there is not this slippery slope of, well, it may count, or if I'm having a good day, I won't let it count, or vice versa. I think we've got to make it consistent.
Thank you.
Second,
well, before you get to the second part, so let's deal with each separately, or we're going to get a little confused. I don't think that's a bad point. Because we're not talking, we're just talking about a list of witnesses, exhibits, and that sort of thing. And so maybe there should be a date certain, I mean, okay, go ahead, please.
Do you want to go first?
I was just gonna say, on our end, once again, and this is just purely coming from a administrative perspective, is that the issue isn't so much the deadline. Like, I agree with Kevin, there should be some kind of deadline. The issue is I guess just maybe some fine tuning in terms of cutoffs or redefining how that works. Like if you say, well, 10 days, is it close of business day or is it 11:59 p.m. on the 10th day? Things of that nature are actually are more in our mind than this. We agree with the hard deadline, but there just needs to be some fine tuning of the hard deadline itself.
Okay, so what I'm hearing, I think everybody agrees. So there will be a hard deadline. We'll have to go back and define it a little bit.
I'd say keep consistent in business days.
Yeah. So, but maybe close of business. So we're figuring out language proposed there, but I think we're all in agreement that there will be a hard deadline when it comes to the parties actually submitting. As far as everybody's agreed on that one, right?
That's a good point. My docs already stated time.
Pardon?
I already stated time.
Okay.
To
So-
if I can word it is.
But as long as we're in theory, so we're all in agreement there. So we will come up with a proposal that'll clear that up. I think it's a good idea. The other part of it, as far as requiring the NCO to distribute the documents.
That was the second part. It's not really clear, but just once again, in a practical sense, there is no defining role on if the parties necessarily exchange it, but then also we've had issues where parties are completely against each other, will not contact each other, but then there's nothing spelled out in terms of the authority of the NCO exchanging, say party A sends it to us, party B sends it to us, and then across over of providing that information, or having those parties directly email each other. Sometimes they do, sometimes they don't. There isn't really
And if it's a resident,
Yeah.
board members are required to have a public email address, but if a resident filed a complaint with a board member, the board member may not have the resident's email address to go back and forth and exchange, so that's something we could help with.
I'm not sure that the parties should be required to exchange. I think anything the NCO gets, and
Yeah.
I mean, if it's,
No,
even if
that
it's
makes sense.
not.
That's just not clear.
No, we don't
here.
disagree. That's
Okay,
just
so you
not
want to make that clear.
Yeah.
Okay, so if everybody's in agreement, we'll make, because, it's just clarity. Okay, so are you fine with a reasonable time? Because, I think a reasonable time would be a day to 3 days. I mean, 3 would maybe start to get a little unreasonable, depending on working days or business days, however we decide to label it.
If it was 10 business, right now it's 10 calendar days, I believe. And so when we have, let's say if after the commission meeting, that's on a Monday, so the 10 days falls on a Friday. So in this sense, if you did say the NCO exchanges it reasonably, if we got it after hours, then we would do it Monday.
Yeah, well, can we change that to, and I'm not sure if this is statutory or not, but if it's not, we could change it to 10 business days. That goes back to that thing. I mean, I think a party should at least have the documents, within, 7 days. They have whole 7 days. So, hopefully.
Yeah, because we could run into issues with, like, say, a hearing being on this day, but then the 10 days prior, the minimum 10 days prior to the hearing could be a holiday day,
Yeah, it's just, I don't think we should necessarily specify exactly how many days we have. I don't, unless you said something like respondent or parties must get it 7 days in advance, something like that.
Oh, we could get information the day of the hearing, the afternoon of the hearing.
I'm sorry, what?
We could get information the day of the hearing or the afternoon of the hearing. I mean,
Yeah, I
you
think
sent that out.
Yeah, but
Oh,
maybe
true.
to what Patrick just said, it's 10 days must be submitted to the NCO, and then the NCO must exchange within 7 business days.
Yeah, I mean,
And
it
that gives
says,
area for leeway.
yeah, it says not less than 10 calendar days before the hearing, so you can't, unless we allowed it, you can't, and we said we won't allow it, so they won't be able to produce, like additional witnesses 2 or 3 days before the hearing.
The other idea was maybe it's noon, because then there's still several hours of working
Yeah,
time.
you can process it.
Yeah.
Okay, so,
that's more where we're just coming from, and giving us, if we're gonna take on that responsibility of exchanging, then
Yeah.
we need the opportunity to be able to actually make that exchange.
so if we gave you like 3 days,
Let's say it's 10 days that the respondent and complainant have to submit to the NCO, and then NCO within 7 business days from the hearing
will our,
must exchange between the parties.
yeah, so we'll have to write that up, but yeah,
Yeah.
basically
But like
that's
10
the
and
idea.
7 would give room.
And that way, each party has it 7 days in advance. So, okay. All right.
Yeah, we have 2 answers.
Okay, Kevin, I think I stopped you at part 2. I don't know if that satisfied you, but.
Yeah, no,
Okay,
thank you
no.
for that. Thank you for the consideration. I thought you as counselor would appreciate having at least some time to review a data dump of witnesses and evidence and everything before you prepare for your case. So thank you for that. The next was the list of witnesses, including addresses, the clause here from the original language. Does that mean email address or USPS addresses? And again, there's the sensitivity of private parties and that exchange. Are these going to be redacted? Why is that clause there? If you want to address that, fine. It may be minor, but then I have the subsequent points after that.
No, that's a good question. I don't know the answer to that. So let us look into that and find. I would think that might be required at the NCO level, but I would think that should be redacted. I don't know. So anyway, that's a good question.
We know that
Okay.
that's just a length there,
Yeah,
but
we have no idea.
yeah, we don't have.
Yeah.
any additional
So.
insight.
Except verifying maybe.
Yeah.
No, thank you. That's a good point. So we're looking into that and consider it and take it from there. Thank you.
Chair, do we
Okay.
need specific language that will preclude the use of city and county resources to help in the preparation of these lists of witnesses? And again, it comes from a historical incident that's been of concern for quite some time. Just want to put that in passing.
Well, I wouldn't think we'd need that because it would be in violation of ethics for any city worker to use that on their own behalf. Steve,
Oh no!
Right?
You said that out loud, Chair. Oh, okay. Just
Okay,
because of
what-
a historical point, we need to table that. I'll talk to you about it offline.
Okay.
All right. So, failure to abide by the provisions may result. Please change to shall result.
Okay.
Otherwise, again, there's
We
no
did
need.
agree to that. So okay.
Bless you. Thank you. Now, lastly, working through the sub process in D, where each step happens.
Well, before we get there, let me go on to someone else. Okay, Kevin? So
Yes,
you
sir.
just hold that thought.
Thank you.
Greg. Greg, is this about part C? If
yes.
so, then please. Okay, go
Yes,
ahead.
I'm up to speed now. As I said, I had just joined when you were talking about the earlier thing that I had asked about. So regarding the hearing notice, since I have firsthand experience with this, as you all know, when I received my hearing notice, the day it was delivered, it was put in my mailbox with a note. I actually didn't receive it. It just was a note that, because I live in a condominium building, that they attempted to deliver. So I picked it up. I believe it was the next day from the day it was attempted to be delivered. And when I opened it and saw how quickly I had to reply, it was very quick to actually meet the 10-day deadline. And now it sounds like you're going to try to change the calendar days to business days, which I guess if I think that out loud, it sounds like it would give additional time to reply. So there is an issue where there's not a lot of time. It was, I think, just over a week, maybe a couple days over a week, that I had from the day I opened that letter to the point where I had to respond with my witness list and my evidence and things like that. And again, I feel this is a completely baseless notice. So I'm looking at that like, okay, now I've got to do all this work. And I did it. And I spoke to legal counsel, and I went over the procedure, and they said, just follow it. And when you send it to the other side. And that's what our judicial process is, as far as I know. When you have any kind of litigation or anything like that, the attorneys always send the documents over to the other side so that they can see what the filing is, and they have due and fair notice. And so my concern with your dialogue tonight is you're trying to change something. And actually, I feel like you're changing it just because it didn't go so well for one of the chairs and the way this is working. And we'll get to that at some point in another week. But it's concerning to me that when I feel like every time I come to these meetings, when you see something that you feel might not be so fair to somebody in a position of power, as opposed to just the general board members, you want to change it, as opposed to making it better for, in my opinion, the board members as a whole, and I'm going to stop right there, as opposed to making it better for the board as a whole, the board members and all of the board members on the neighborhood boards. And that's a concern I have. So I'm sharing that with you because I keep seeing that from the things that you guys are trying to steer and veer into different directions. Thank you.
Okay, I'm not really sure what to take from that, other than you didn't feel like you had enough time to respond. But, these rules apply to everybody, so it's not, I take a little umbrage to the fact we're trying to change it to give anyone a preference. We're trying to streamline the appeal process. The process. If maybe the fact of we can kind of consider how long a party, once they're notified, has to file, maybe we should take a look at that, because I don't know, like me personally, if I've really thought it a timeline through. So that's something we'll look at and see if there's enough.
Could I add one or two sentences, Chair, just to extend what I was trying to explain if you didn't understand? Okay, so what I was basically asserting is that, in the case of my hearing that I have to deal with for something I didn't do, I followed the procedure. I'm a procedural person. That's my background, engineering, and what I've done in my career. And I got advice to follow that procedure, but the other side didn't. And when I went to the hearing, and I'm sitting there in the hearing, waiting to have my day in court, you guys decided to change the rules and just said, well, we're not gonna hear it tonight. We're gonna defer it because I objected to the fact that the other side didn't follow the rules.
Not great. Yeah. Okay. You're talking about.
That's important. That's important to the process.
Yeah,
so it's procedural.
we're trying to change it for the future. This is about a proposal. So if you want to suggest a change, please do so. But you can't talk about the current plan. We're trying to change it and talk about a new proposal so that we
So
make
my
it.
suggestion is this. Here's my suggestion. You delay
Okay.
these complaints a long time. I mean, so many of the complaints that I see filed, they get delayed for many, many months. In this case, you pushed a case to a hearing after so many months. And when you send out these notices, you should do it so that there's an additional month for the hearing, not so that it's within that same month. You should give more leeway in that. And I think the 10 days is fine. I think the way that is currently is fine. It's just that it's too soon from the notice of when you set the date for the hearing. So push the hearing out to another month and then provide the 10-day notice the same way it is now, but serve the notice of the hearing much sooner to the way you're doing it currently. Because when I received it, I was blindsided. I'm like, how is this even going to a hearing? But now I have this little window of time to reply. And we all have things in our lives to do. I'm involved in quite a bit, and I think all of you are. And none of you would want to sit there and have to go through that. So that's my
appreciate
suggestion.
the comment. Thank you. We'll take that under advisement. Please.
Yeah, I
Thank
just wanted to mention, Greg, the point that you brought up, that you got your certified mail 2 days later. We're trying to come up with a solution for that, where there's multiple ways to communicate with the individual that's getting that certified mail. Getting an email from the NCO letting you know that you have a certified mail that was sent to you, so you know not to wait 2 days in your mailbox. You know that it's sitting in there, you're gonna go pick it up. And then the other thing too is, if for some reason they didn't hear from you to authenticate that's on that email, we can pick up a phone call and grab your cell phone.
Thank you.
Picking up because you had emergency leave, you had to go back to the mainland for 3 days or whatever. At least we know that we contacted you. Now the ball's in your court to figure out, to come back and say, put a special request in to say, I can't make it back in time. I can't answer. I can't be ready for this hearing because of emergency situation. That's how that communication is going to work. It was broke before, and the commission here is fixing that situation.
Excellent. Thank you, Chair. Thank you, Commissioner Bure. Thank you. That's excellent.
Thank you, Dylan.
Yeah, I was just gonna dovetail off of what Mr. Bure said, is like, yeah, that's where we're coming from, because, you could send someone out a letter even 30 days in advance of something, but it could take 5 days just to get to them by the post. And then if that person's not home for 3 days in a row because they work, well, that letter can bounce 3 times before it even gets to you. So that's what we're trying to resolve here. Because like I said, I mean, at a certain point you go, well, how long before, when, you could send something 30 days in advance, they might not get it for 15.
Okay, so we will.
One more thing.
Okay.
And Greg, I want you to know that this commission felt some of your pain. We wanted to expedite some of these things, but we were restricted by what was in the plan. So that's fixing that right now.
Okay, so we will take that under advisement. Thank you, Greg. Since we're going to move to, I don't think we have any others besides Greg, right? Since we're going to move to section D, we're going to go back to Kevin Lott, since I cut him off about section D. So go ahead.
Chair, thank you for letting me be a second-time speaker. Briefly, within subsection D, part number 2, will this be an opportunity where a complainant can submit evidence of non-response of the respondent to an allegation, and hence admitting the allegation? At least somewhere in the process, I think this might be the appropriate place to do that, where it can at least be registered in front of the commission or a hearing officer for the process.
Well, we have low evidentiary requirements, so I don't think there's anything in here that would prohibit a party from saying the other party has not responded to a particular allegation, and maybe you could say the sufficiency of their response, that sort of thing. So you're entitled to say whatever.
Okay.
And
All right,
if you
thank you.
yeah, I think that's already built in here because there aren't high evidentiary requirements. So I can't imagine why you'd be precluded from doing that. Does that
I
answer
guess
your question?
it was more of a question of, it can be submitted, yes, but will the deliberative body consider it as a defined reason. It's in the neighborhood plan up above, saying if you don't reply, you're admitting what went wrong, and that may be because you just don't want to deal with it, or the respondent may really realize there's really nothing to be said. The difficulty is when there is no response, yet the respondent then comes to the table and tells a nice story, and that admission of the allegation is kind of thrown away. I think that's one thing that's happened in the past. I'm trying to see if there's a way to have that have some teeth. Just a thought for later consideration.
Thank you. As you recall, we just talked about the failure to reply was not necessarily deemed an admission, I believe. But here we talk about failure to produce lists of evidence, witnesses, exhibits. That's a different story. So, yeah, I mean, you at any party can, well, I'm repeating myself, can allege that the other party has not sufficiently denied something. And you can assert that the suggestion, the conclusion should be that they're guilty, so to speak, of whatever. So I don't see any issue there.
Okay,
Does that
thank
answer
you.
your question?
I'll look at the language above with I think you're referring to section G, the last sentence there about failure to file a timely response and how that compares and comports with the failure to provide witnesses and whatnot. Two separate things.
Yeah.
Okay,
Right.
I'll review that.
Okay, thank you. Is that
But
it?
the key thing here, Chair, is item 10, subsection C. This is a case in which a hearing has been led by a hearing officer. The hearing officer generates a report. The language here suggests, if not states, that the commission shall review that report and later shall issue a decision within 60 days of mailing and ostensibly receiving the hearing officer's report. So the issue has arisen wherein the commission issued a decision prior to receiving and or reviewing a hearing officer's report, rendering this 10C meaningless. So I wonder what protections can be put in place so that abject failure for complaints 2020-07 and 2020-08 does not happen again, because it was very deleterious and is still an outstanding question that's been posed to the commission to address why that happened without resolution. I just hope that we can find a way to do that. I suggest the addition of this language for subsection 10, subsection C. The commission shall review the hearing officer's report and recommendation and all objections, and afterwards shall issue its decision within 60 days of the date of mailing of the hearing officer's report, etc. The difficulty here that leaves is that the hearing officer may be late in providing a report close to that 60-day mandate. So it might mean that language should be modified further to permit receipt and review by the commission of that hearing officer's report before they are then mandated to issue a report of their own about the hearing process. Happy to go through the details again. A gaming situation where you test this out and play it out, it would be a good way to make sure the language in the final version is useful. But I just want to make that point. Thank you, Chair.
Thank you, and we'll definitely take that under advisement. Appreciate the input. So that concludes then section 102. Are there any last further comments? Obviously, sanctions would become 103. It's the Willego. That's because this is a rough draft. This was just purely taken from the current plan. So if anyone wants to take a quick look, there again, it's something everyone can look at over until we have our next meeting. So if there are no questions or concerns, is everybody good?
It's interesting that this section doesn't include the committee member.
Yeah, I wonder if that was a mistake. Yeah. And then what sanction would you have other than saying they can't serve? So there again with contested case procedure, that's pretty much statutory. That comes from the current plan too. And I'm not sure we really can change that. So now that everybody's seen this, at least we've done an initial kind of quick review. I hope everybody takes the next month, assuming we meet next month. Okay. And we'll take a look. So I'll take any questions. And who's the first? Kevin, go ahead.
Chair, thank you. I guess I'm just concerned a bit about the ease with which a complainant may end up being sanctioned at the end of the hearing process. Unless a complaint is, as in subsection D7 above, frivolous or filed to embarrass or cause harm to an individual, it's hoped that that type of complaint will be filtered out through the processes of review by the executive secretary and the commission chair prior to this whole thing starting. So I'm just wondering if it's possible that something could be deemed or found to have been frivolous or filed to embarrass or cause harm to an individual during the hearing process. If so, maybe that is something that's worthy of a sanction to the complainant, but hopefully that would not happen. But outside of that, I think that's where the concern may be. And because if a complaint is legitimately filed and it turns out that a report by the commission or hearing officer recommends sanctions to everybody, then I think that could be a chilling effect. I just hope I'm going to try to look at that language in more detail. And then before I go, I'll sign off here, but at 218.105, there's an extra closed right angle bracket at the next to last line. You might want to strike in the next version, but thank you, Chair.
Thank you. Okay, we'll take that under advisement. Thank you. Who's the Greg Marsakian, please go ahead.
Thank you, Chair. So yeah, I echo what Member Lai just said. I was going to allude to that, but also to take it a little bit further. You're given some guidelines as far as imposing sanctions. You're given some guidelines. They're pretty much vague and ambiguous, putting them into the hands of one gatekeeper as far as if a complaint is, should be suggested to be dismissed or not. And so there's the front gatekeeper, then the commissioners make a decision based on the recommendation of Executive Secretary Lloyd, Yananaka, and then there's the next level. And so in the case of what I'm dealing with, not to get into the specifics, just but to talk top line, you've got something where there's a complaint that talks about a lot of stuff where the witnesses are coming in with crazy things that I never did from months ago, and nobody ever filed a complaint or raised a concern. And this is just an example of what the concern is with this section and the whole process. And so specifically to the sanctions or what you could actually put forth as a penalty. And in the case of a situation where you have someone like that there's no evidence that they did anything. All the witnesses that are reviewing the video said, I don't see anything you did wrong. There's no specificity to what is stated that the person may have done wrong. So I'm just using mine as an example because it's close to heart. And then you're going to make a decision on that, on what basis and what governance, what outlines as far as what you can actually impose. I realize you can do this, this, and this, but with what authority to suggest that you have evidence to support that decision? So where is the evidence? Will you state, we see evidence of something where a person yelled or said a swear or something like that, which we know happens and we've seen it here, even at the NCO. Will you provide that? Is that something that you can please state in this section? I think this is where you need an amendment to be specific about what you will actually do to view, and what are the levels that you can actually impose these things. Otherwise, it's just a wild west of do whatever you want, and go to jail, go directly to jail, do not pass go, and you don't even land on that spot, but you go there anyway in a Monopoly game. So I'll end there, but I'll end with Monopoly, but it's not right. And everybody that knows this on other boards that have spoken have said it's not right. We all know it's not right. And I truly hope you do the right thing, because this is really going to an extreme level, what I'm seeing right now, at least with my situation. And I don't know with others, I can hear rumblings, and I don't know the specifics of their cases. So thank you.
Okay, well, if you want to send me any specific suggested language, and it doesn't have to be wordsmith exactly, but the kind of the concept you're talking about, I'd be happy to bring that back to the committee and we can consider. Okay?
Thank you.
Are there any last comments? Hearing none, thank you everybody for joining us, and please review this. If you have any questions, any suggestions, we'd love to hear from you. We're trying to make this more fair and to streamline it and make it better. So any suggestions you have, please don't hesitate to reach out to us. Thank you. And just an announcement is we will have our next meeting on May 19th, which is a Monday, here at 6 p.m. Are there any other announcements? Hearing none, we are adjourned. Thank you.